Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello, welcome to the new series of our Equity Capital Markets podcast, focusing on all things ECM. Today I'm joined again by Deborah Chu, partner in Melbourne, and Chris Wright, a senior associate in Brisbane. Welcome to you both. Beautiful spring day here in Melbourne today. It's moving into spring, but also moving into AGM season, and companies obviously beginning to pay attention to what should go into their AGM notice. So we thought it'd be useful today to talk about when is shareholder approval required in the context of a capital raising. So Deborah, maybe starting with you. So we're mainly talking about placements.
Yeah, well, just to set the scene a bit, the two key ways that a company might raise capital could be through a rights offer to all of its shareholders, pro rata in accordance with their shareholdings, or through a placement. And the ASX, for example, prefers a rights offer because then it allows all shareholders to participate, particularly because when a company does capital raising, often it's at a discount. Well, invariably it's at a discount. And so that way all shareholders can benefit from that discount to the market price. But from the company's point of view, a placement can be better because that's targeted. It can be very fast. You can do it in just a few days. And often you may be able to raise more than you might be able to raise in a rights offer, or you might be more likely to be successful in it because a lot of rights offers aren't necessarily taken up. And do you have an underwriter? Do you not have an underwriter? So placements can be terrific, provided
you don't need shareholder approval.
Exactly. And there are certain categories of persons who would be the likely suspects to participate in a placement, where because of the Corporations Act and the listing rules, you would need shareholder approval. And we'll talk about that further in this podcast. But key categories would be related parties and shareholders who hold 20% or more of the company's shares.
So Chris, maybe let's sort of delve a bit more deeply into when is shareholder approval required in the context, particularly of a placement.
Thank you, John. So you can think of the need to have shareholder approval fitting into two categories, something to do with the shares themselves that you are issuing, or as Deborah alluded to, the person or persons who the shares are being issued to. In that first category of the shares that are actually being issued, the key place that shareholder approval is needed is where you are issuing shares outside your existing issue capacity. So all companies listed on the ASX have a certain number of shares that they can issue every 12 months, and that is 15% of their current share capital under listing rule 7.1, and then an additional 10% under 7.1A, provided they've jumped through a couple of extra hoops, having this approved at their AGM. So if you're issuing shares within that capacity, then in theory you're fine, no approval needed. If you want to issue shares outside that capacity, so then you do need shareholder approval, unless you fall within certain exceptions. The big exception, which we've alluded to earlier, is an issue for a pro rata rights offer or an entitlement offer. For precisely the reason that Deborah mentioned, you can understand the commercial reasoning behind it. If all shareholders are getting the opportunity to participate, then in theory, none of them are diluted. And so there's less need to have them approve a particular issue. If, however, you're making an issue under a placement, that could potentially have dilutive effects. And again, you can see why the ASX would want shareholders to have some say over shares that are being issued in that case.
But to achieve the objective of conducting the placement as quickly as possible, you need to make sure you've got maximum placement capacity.
Absolutely.
Available as much of the time as possible. So talking here, I suppose, about ratifying any prior issues so that you can start the new year with full capacity.
Absolutely. So you can either have your shareholder approval before the issue of shares, in which case it doesn't count towards your capacity at all. But exactly as you say, John, shareholders can ratify a previous issue. So even if a company has used up part of its capacity already, it can subsequently have shareholders approve or ratify that issue, and therefore their capacity is freed up again for future use.
Yeah.
And, it's funny because you might look at that placement capacity and think, wow, that's quite a lot. It's 15% plus another 10%. Shouldn't that be enough? But, there are companies in this world and in this environment who aren't profitable yet.
Yep.
And who have a very strong need for equity, and who might be, whose shares might be pretty thinly traded, and therefore it might be difficult to raise enough.
And that kind of company, quite often, the founders of the company or the promoters of the company are related, are directors or related parties.
Yeah.
And so,
or 20% shareholders.
or 20% shareholders. So let's maybe talk about those categories where shareholder approval generally would be required because of who they are.
Yeah.
Um,
And because they would be the most likely prospects for a big raising in a case where the company needs a lot of funds and either has gone through its placement capacity or where there's just not enough investors out there who want to take up the shares
and are there any
who are not related.
Any useful exceptions under the listing rules to allow you to issue to those sorts of parties?
Well, the best one is the one that we've already talked about, which is the rights offer.
Right.
But rights offers can be useful or not.
Yeah.
And sometimes you may simply want to get shareholder approval. Yeah. Depending on your needs and whether a rights offer would be sufficient. So if you are in that scenario where you really want to issue to a related party, and also you need to be aware of who under the listing rule 1011 would be covered by this requirement to get shareholder approval, because it's not just the Corporations Act definition of related parties. Yeah. They are certainly included, that being directors, close family members, say parents or children, companies that are controlled by directors, those sorts of entities would be related parties. Yep. But the listing rule also extends to parties who are not related parties under the Corporations Act, such as a 30% shareholder, or even a 10% shareholder who has nominated a director under an agreement with a company that gives them the right or an expectation that they can nominate a director. So that 10% shareholder, even though they're under the 20%, any issue of equity to them would require shareholder approval as well. So, it's a pretty broad category. And then under the Corporations Act, related party benefits provisions, you also need shareholder approval if you are issuing equity to a director or the director's related parties, unless an exception applies. And quite frankly, in most cases, an exception would apply because there is a key exception for arm's length transactions, which are transactions where the equity securities are being issued to the director or other related party on terms that are on arm's length or are more favorable to the company than arm's length. And for most issues of equity, you should be able to meet that standard. And quite
Because it's on
frankly,
the same terms as everybody else.
exactly.
Yeah.
And you wouldn't want to be issuing
No.
shares to a related party without the terms being fair.
Yeah.
Because
Where-
that would just look really bad.
Yep. No, Chris, go.
Agreed. Where it can sometimes get tricky is where the directors are issuing shares to several directors, and there may not be enough directors to form a quorum, a disinterested quorum, to make the determination that the issue is on arm's length terms. And that's exactly the sort of situation where a company might seek shareholder approval, even if they are comfortable that they're on arm's length terms, because they just don't have a disinterested number of directors who can make that determination.
Yeah, no, that's interesting. And Chris, we should probably just talk also about the takeovers issuing to a person who's already, and their associates already hold 20% or more of the company.
Yes.
So that how could we go about doing that?
So this is another place where it is the person to who you are issuing shares that causes the need to get shareholder approval. We've spoken already about related parties, the expanded definition under the listing rules. It's not just people who are directors now, it's people who might become, who have expectation of becoming directors or associate in the future, or who have been directors in the past 6 months. It's a very broad category of people. Added to that is then the takeovers requirement, which is that a person cannot be issued shares such that they would go over a 20% holding in the company without certain exceptions applying, one of which is the obtaining of shareholder approval. So if a person would be issued shares and their holding would go from below 20% to over 20%, or if they already have 20% or more, if there is any increase at all in their shareholding, that's when you'd be looking at this takeover requirement, either to fit within an exception or that you have shareholder approval. What are the exceptions? Obviously, there's making a formal takeover bid, which is a big, long, expensive process, which people don't particularly want to go through. There is also then other exceptions, such as for pro rata issues, as we've discussed. 3% creep. So if you already have over 20%, you can increase by 3% over, I believe, 6 months. So there are a number of ways that you can increase it, but yes, the biggest one is getting shareholder approval.
I would need an expert's report, would I, in my notice of meeting, that issue of shares to a 20% plus shareholder that is outside creep?
It would be very common to get one. There are a number of things that you have to include in your notice of meeting so that shareholders are appropriately informed, and that includes things like the identity of who is actually getting the shares, fundamental thing to know, the extent of the increase that they're getting, the voting power that they'd hold, and the effect and reasonableness of the transaction itself, which is where you might look to get an independent expert's report.
Yeah.
And the expert report requirement is always an interesting one because you have the additional cost, and you want to make sure that the expert's report would come out as saying that the issue is fair and reasonable. There's an argument in the context of a straight issue of shares where you're issuing shares on no particularly special terms at a discount potentially to the market price. But in that case, it's quite clear what the value is that you're issuing the shares at, because really the value is getting the shares at that discount. So whether you would actually need an independent expert's report in that case or not is a question. And it also comes up in the related party benefits context, because ASIC, under its regulatory guide, has said that there may well be circumstances where you should get an expert's report, but it tends to be in a case where it's difficult to value the benefit that is being given in the context of the particular issue. And that may not be the case in a bog standard fair issue.
Yeah.
I'll note actually in that context of needing shareholder approval in order to go over 20%, that you also need to be aware that it's not necessarily just the shareholder as a single shareholder who the 20% standard applies to, but it's the shareholder and its associates.
Yeah.
And whether taken together as a group, whether the issue would be over 20% or would take them over 20%.
Yeah.
And so associates are, there's a test under the Corporations Act for who an associate is, and certainly any companies that you control would be an associate, but also parties who are acting in concert with the main shareholder, or who have a relevant agreement with that shareholder in relation to the company's affairs. They would be associates. And interestingly, whether a person is an associate is a different test than whether a person is a related party under the Corporations Act, because under the related party definition in the Act, parents are by definition related parties. But for the purposes of an associate relationship, a parent isn't necessarily an associate, but could well be, given the relationship. Or spouse. Exactly.
Yep.
So in looking at how the Corporations Act applies and how the listing rules apply in the different contexts, you really need to focus on the particular thing.
So quite a bit to work through. So I've worked out that I do need, under one of other of those, for those reasons, do need shareholder approval. So that I then put together my notice of meeting. Is there any sort of particular comments or observations on, Chris, on what needs to be included in my notice of meeting?
Absolutely, and unfortunately, it depends on the type of situation you're in. But each of the Corporations Act and the ASX listing rules have in them requirements that must go into a notice of meeting. Usually, it would be who at the very base level, who the person is, how many shares they're getting, what's the value of those shares, and an idea of what the dilutive effect would be on the other shareholders as a result of that issue. Those are the sort of key things, but it's definitely a case of checking the exact wording of the legislation to make sure you're meeting the exact requirements for each type of approval.
And ASX needs to approve my notice of meeting, and they have up to 5 days to do that.
They do,
so
yes.
They do a bit of lead time.
Yes, and where you are looking to get Chapter 2E approval, which we've touched on basically, you also need ASIC approval. They have 14 days, so even longer, although you can apply to reduce that.
Yeah.
And interestingly, particularly in the context of a 20% shareholder, if there would be control implications to the share issue, that would need to be covered as well.
Yeah. Very good. Deborah, Chris, anything further to add? Or, quite a lot to digest there.
One thing that is clear from this discussion is that it takes time to plan for this kind of offer. So, quite frankly, where we are now, if the company hasn't done the work already in order to tee up the things that it needs to tee up to get this shareholder approval, or to propose an equity issue for shareholder approval.
They need a lawyer quickly.
Yes, we're always here. But you would really need to be working on this now, or quite frankly, in the previous month, in order to have time to get everything into your notice of meeting. And also, you would need to think about whether there's anything that you would need to get the ASX to waive in order to be able to do the share issue. And that always takes a little time.
Yeah. Great. Thank you, Deborah. Thank you, Chris. Thanks, everyone, for listening today. In next week's episode, we're going to be discussing continuous disclosure and cyber breaches. So not to be missed. I hope you'll join us for that. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. And if you enjoyed today's episode, then please rate, review, or follow our podcast wherever you get to your podcasts. Thank you.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.